Welcome back to the Liberty Block. This is Alu Axelman. Great to be back with you. I want to take some time to discuss one of the numerous dozens of Supreme Court cases published this term, a lot of them in June, that is interesting to me. And since this is me and my video, I will talk about what's interesting to me. One of the cases is Chiaverini versus City of Napoleon, Ohio. This case was decided 6-3 in favor of the plaintiff Chiaverini. I believe he's the plaintiff in this case. This man, Joshua Chiaverini, was a manager of a diamond and gold outlet in Napoleon, a city in Ohio. And I'll just give the background as presented by the record in the Supreme Court case on oyez, oyez.org. It's an awesome site. So, long story short, pretty much this guy, Chiaverini, ran this store, diamond and gold store, kind of like a jewelry shop, pawn shop kind of thing, maybe. He apparently bought someone's ring. Someone came in and sold a ring and diamond earrings to him. A man named Brent Burns sold it to him for $45. And this is only a few years ago. He recorded the transaction and copied Burns' ID and photographed the items. Subsequently, David and Christina Hill contacted Chiaverini, claiming the jewelry was stolen from them. So they said he had bought a stolen ring and earrings. So it's stolen property, but he bought it from someone fairly, or so he thought. So that's an issue. Chiaverini advised them to report to the police, but denied buying their items. After multiple calls, Chiaverini ended the conversation. Both parties contacted the police. Chiaverini expressed his suspicion about holding stolen property and requested that police, not the Hills, to visit the store. When the police arrived, Chiaverini cooperated, providing information and photographs of the jewelry. The situation escalated when Chiaverini received a conflicting hold letter from the police, telling him to keep the items as evidence. Also, some contact from the police told him to release them to the Hills, the people who claimed it was rightfully theirs. So he got two conflicting letters from the police or other correspondence from the police. Chiaverini refused to release the items to the Hills, citing legal concerns and advice from his lawyer. His confrontation with the police, the chief Weitzel of Napoleon, revealed Chiaverini's lack of precious metals dealer license. So in talking with the police chief Weitzel, the police discovered that he did not have a license as a precious metal dealer. So that prompted the police, because they had a confrontation, and I guess some police didn't think Chiaverini was cooperating enough with them, possibly because of the conflicting letters or whatever miscommunication. They started investigating him for the lack of a precious metal dealer license, which I think is a misdemeanor in this city. Officer Stewart updated the police report to include Chiaverini's suspicion about the stolen nature of the items, which Chiaverini disputed. Based on these developments, warrants were issued for Chiaverini's arrest in the search of his store, leading to him being detained in jail. I believe he was in jail for a total of 2 or 3 days, depending on the exact brief that we look at, I think. Although a court later dismissed the criminal case against Chiaverini, he filed a complaint, so he sued the officers in the city of Napoleon, alleging various legal violations, the primary one of which is, I believe, malicious prosecution, which in this federal lawsuit against police for violating your rights, malicious prosecution is essentially a false arrest kind of lawsuit, saying they falsely arrested him, which generally means without probable cause to think they committed a crime. And we'll get into that, and that's what this whole case centers about. It turns on what that means. The district court, so the trial court, the lowest level federal court, granted summary judgment to the officers. So they quickly ruled in favor of the officers, citing probable cause for Chiaverini's arrest and dismissing his claims. The U.S. Court of Appeals for the Sixth Circuit affirmed that decision. The question before the court is, may a Fourth Amendment malicious prosecution claim proceed as to a baseless criminal charge so long as other charges brought alongside the baseless charge are supported by probable cause. Now, what this case is really about is, and it gets into it if you go to Justia, Justia. That's like the best site that I've seen for reading in pretty simple format the Supreme Court decisions. It doesn't simplify it. It's like the literal decision, but it's not a PDF. It's on a web page, and it's just decently easy to read. In this decision, a few things as more background is, number one, he was charged with two misdemeanors. One was, I believe, receiving stolen property. One was operating this jewelry store without a precious metal dealer license. And he was also, at the time, when he was arrested, the police charged him with three crimes, or arrested him on suspicion of three crimes. And those two misdemeanors, and the felony was money laundering, which I've discussed before. It's a very general felony. This was the state money laundering statute, I guess. If it's similar to the federal money laundering statute, it's very broad. It means having any money that could have been used in the past or future, I believe, in any crime. So proceeds of a crime or money that could be used for a crime. But any money that was previously involved in any crime in the past, it's ridiculous. There's some mens rea. You're supposed to have knowledge or intention that it was proceeds of stolen money, money laundering, but whatever. So it turns out that it seems to be undisputed in the record that there was not probable cause for that felony money laundering charge. There was probable cause for the two misdemeanors. He was arrested for all three. Now, I just spoke to another lawyer the other day, and he said absolutely, in regard to arrest, all you need for an arrest, like for police to actually handcuff you and arrest you, is probable cause for one crime, one misdemeanor arrestable offense. Every jurisdiction is different. In general, even a misdemeanor could be an arrestable offense. Many times, police will choose to give someone a summons, just give them a ticket, a fine, and tell them to go to court and fight it or pay it if they want. But technically, I think police have discretion for any misdemeanor. If they have probable cause to believe you committed it, they can arrest you, I believe. But anyway, that's all they need for an arrest. You can't say it's a false arrest. The reason he sued them with the 1983 lawsuit for violating his civil rights was violating the Fourth Amendment, unreasonable seizure of his person. They seized him by arresting him and putting him in jail. So it's the jail part, I believe, because he sat in jail for, I think, more than 48 hours. Now, here's one of the things that's essentially the core of this case is he was arrested for suspicion, probable cause of three crimes, two misdemeanors and a felony. Everyone admits now the felony was not based on probable cause. The two misdemeanors did have probable cause. And by the way, the prosecutor dismissed all these charges. So none of them ultimately led to him being convicted. And that's related to a Supreme Court case 2 years ago that they reference 100 times in the oral arguments. And I'll discuss that in a minute. But that one felony, money laundering, it seems to be essentially not disputed really, that the police officers lied to the judge to get that warrant. They lied about the money laundering. They cooked the reports. They lied on the affidavits, saying that something happened that did not. I'm not sure exactly what it was, but they seemingly violated some laws and policies in obtaining the warrant for the felony. Now here's what it all comes down to. He was held in jail for like 2 days. Generally, for a misdemeanor, like non-violent misdemeanors of receiving stolen property, $45 worth of jewelry, receiving it without knowing, and having a jewelry store for a long time but didn't have the right licenses for it, with those kind of misdemeanors, probably he would not be held in jail for 2 days, detained before being bailed out. He probably wouldn't be arrested. It would probably be a fine, a summons, and if he was arrested, it would be a quick booking and he out in a few minutes and not held in jail. The fact that he was held, probably, and what would most judges do as far as deciding whether to hold someone in jail before letting him bail out. The Supreme Court discusses what would they do, what could they do, what would most judges do, what would this judge have done. They discussed that a little bit toward the end. But was he held because there was a felony count? So he's facing 3 charges. One's a felony. Was that the reason he was held for 2 days in jail? Probably. I think it's reasonable to presume that that's probably the case. If not for the felony, and that's why courts will sometimes use the but-for kind of analysis of but for the felony, meaning if not for the felony, he probably would not have been in jail. And since the felony did not have probable cause, it was based on police officers lying on an affidavit, which again I thought was perjury, but whatever. I guess they're not being prosecuted for that. But then that's an issue. That would be probably a violation of the Fourth Amendment as an unreasonable seizure. Seizure applies to things as well as the person himself. So they seized him and put him in jail. And he went to jail because of that. And even though it was the judge who technically held him in jail, made the decision, it was the police who lied on the affidavits to get that felony charge to be brought with a warrant. So that's kind of the background of the case. Let's see what else it says here in my article, because I published an article on this a few days ago on libertyblock.com, so I'll link that article in the description, of course. The Supreme Court says in order to win a malicious prosecution lawsuit against a cop, the plaintiff must prove three things. One, the appropriate intent by the cop. Two, favorable termination of the case, meaning that it did not result in a conviction, which it did not. I believe the prosecutor dismissed the charges. And three, initiation of legal process, which I guess just means beginning to prosecute him, which I think happened in this case. So those three things apply. They discuss a fair amount of what they discuss in the oral arguments, from what I heard, is Thompson v. Clark, which was a 2022 case in the Supreme Court. In that case, the simple outcome of that case was kind of a simple ruling the Supreme Court made that in order for these kinds of lawsuits, these malicious prosecution, meaning false arrest lawsuits, to go forward, you need a favorable termination of the case. What does favorable termination mean? Does it mean acquitted? A jury found you not guilty, innocent? Or does it mean any conviction, any termination other than a conviction? So that could include a dismissal, which is another big type of category of disposition of a case. A case could be, you could be convicted, you could be acquitted, or a lot of cases are dismissed. I suppose some have some other dispositions, various settlements, guilty plea, which is essentially a conviction. But dismissal, that's a big one. So the three big ones is being acquitted, being convicted, or being the case being dismissed for whatever reason. So in that case, in Thompson v. Clark, the Supreme Court held that all you need is a favorable disposition to a case, and that could include anything besides a conviction. So if the case did not lead to a conviction, then that means that the favorable termination, remember those three prongs, then that prong is satisfied. That was prong number two in these malicious prosecution lawsuits that you need in order to even bring the case. So that's that explanation. The Supreme Court does some more explaining here, and then let me see what the next big issue was. Then there was a circuit split, meaning various appeals courts have ruled two different ways. I think they said the Sixth Circuit ruled in favor of the police in this, but I think there were one or two other circuits that ruled the other way. And whenever there's a circuit split, that makes it a lot more likely that the Supreme Court will take the case, obviously because federal courts of appeals have been split on the issue, so it makes sense. So that's another reason I took this case. Ultimately, the question, the parties agreed, and then I think because this was against the city, apparently there was like an amicus brief or something. The federal government told the Supreme Court they agree that the police violated the procedure and really violated some laws, I believe, by lying on the affidavit to get the felony. So I think what the Supreme Court says is like everyone agrees, including I think the city of Napoleon and the federal government, and obviously the plaintiffs, the victim Chiaverini. They all agree that there was lying and the felony should not have ever been brought against Chiaverini. So, but ultimately the question is going to be about causation, right? Was he held in jail for those 2, 3, 4 days, whatever it was? Was he held in jail because the judge approved the warrant that involved a felony? If not for the felony, based on the cop's lie, would the judge have approved the arrest warrant, and or would the judge have allowed or forced Chiaverini to stay in jail for those few days? So So and the court says in the majority opinion, quote, and the question is not close, as shown by the parties' decision not to contest it in this court. The parties, almost needless to say, have found substitute ground for disagreement. So they found something else to disagree about, which involves the element of causation. As noted earlier, a Fourth Amendment malicious prosecution suit depends not just on an unsupported charge, but on that charge is causing a seizure, like the arrest and 3-day detention here. So yeah, the court says 3 days. I think someone else had 4 days and someone else had 2 days. But anyway, the Supreme Court says 3 days, so that we can go with that. That probably could be the case. The three parties, so the federal government, I guess, intervened or did an amicus brief or whatever, because they weren't really party to this case. It was between the police and this person, Chiaverini. But Chiaverini, obviously, all three presented a test that they want the court to use to determine whether he could sue. So really, this is all about not like a case on the merits. This is about whether a lawsuit could proceed, almost like a standing kind of thing, or like a qualified immunity kind of thing, of whether you can even get into the courthouse to sue. So, just in case anyone's confused, Chiaverini is trying to sue in federal court under Section 1983 of the Ku Klux Klan Act, which is what empowers, authorizes citizens to sue police officers in federal court for violating a federal right. In this case, the Fourth Amendment right to not be subject to unreasonable seizures. In order to get to the courthouse door, you have to satisfy some tests. There are various ways those doors could be locked to you. There's qualified immunity. There's for malicious prosecution lawsuits. In this case, there's these tests. And one of them has to be that there was not probable cause. So the question in this case is if really the question, I think the way the Supreme Court posed it, and the way I think I wrote it here, I think I wrote it in my article, like the ultimate question, and it's not even here. Sorry, let me try to find it. I mean, pretty much it's, does the presence of one legitimate charge insulate cops, protect cops from even being sued for malicious prosecution for baseless charges within the same arrest? If they arrest you for one or more probable cause charges, so legitimate, and one or more charges that did not have probable cause, can you still sue them for the bad ones? So does one apple spoil the bunch, or does one good apple protect the bunch? So it's kind of the way to look at it. That's, I think, the best way to pose this question. So ultimately, what it came down to was causation in this specific case was, since the bad one was a felony and probably the reason that he was held in jail for those few times, for those 4 days, that means that the Chiaverini should be able to sue the police for that. And again, it doesn't mean he'll win. It just means he can get into the courthouse and have the lawsuit. Whereas the police were hoping. So anyway, so the three tests that they presented were, in Chiaverini, he said when both invalid and valid charges are brought before a judge for a probable cause determination, the warrant the judge issues is irretrievably tainted. So any detention in jail, depending on that warrant, is the result of invalid charge. So he's saying if there's any invalid charge involved, which there was one here, and everyone admits that, then the entire warrant is tainted, any seizure, any holding in jail is tainted, it's all bad, the police are wrong, he could definitely sue them because this was wrong. Now the test that the federal government submitted, and they want the Supreme Court to use, was the but-for analysis. So that to determine whether the invalid charge, apart from the valid ones, caused the detention. The question then would be whether the judge, in fact, would have authorized the detention had the invalid charge not been present. Now, the third test, the police officers of Napoleon, that city, the defendants in this case, the officers urge a stricter test. In their view, the question is whether the judge, absent the invalid charge, could, so the other was would with W, this is could with a C, could have legally authorized the detention, regardless of what he really would have done, but for the invalid charge. And I wrote here in parentheses, can't judges hold anyone in jail for any misdemeanor? Yeah, probably. They have, my understanding, I don't know Ohio law, but in every jurisdiction I know about, I believe judges, like I said, for any misdemeanor, which they all seem to be essentially arrestable offenses. Police can arrest; they have discretion. Judges, once they're arrested, have discretion, depending on the jurisdiction. I guess here it's a judge. In other places, it could be a bail commissioner or the police or prosecutor, maybe, who initially decides how long to hold you in jail or letting you have bail. But generally, I think that the general rule is judges determine bail, whether you can leave jail. So the federal government says use what the judge would have done. The police are saying what the judge could have done. So the cops are saying, Supreme Court, we ask you to please use the test to analyze this within the framework of what could a judge have done. And since any judge can hold anyone if there's any legitimate charge in there for anything, they can hold you in jail for as long as they want until the trial happens, then they should say that the police are insulated from lawsuit. Because they're saying the felony bogus charge that the cops lied about in order to get the warrant, they're saying that didn't make a difference because even if just the two misdemeanors were there and the felony didn't exist, still the judge could have held him in jail, which is true. It seems like the Supreme Court used the middle test. And I'll go to the case here to make sure that they used the middle test. In the 6-3 decision, that the but-for analysis, which I think makes the most sense. I'm a little sympathetic to Chiaverini, the plaintiff against the police here, for him saying the tainted kind of analysis of anytime there's anything bad, it taints one bad apple, spoils the bunch. The whole warrant's bogus, therefore it's wrong, and I can sue. I'm also sympathetic to that because he's not saying he should win the case on the merits. He's saying, let me at least into the doors of the courtroom to sue the cops. But anyway, they used that test, I believe, the but-for test. So that's Chiaverini. I explained Thompson v. Clark. That's the Chiaverini case. Let me see if I have anything else here. I think that's pretty much the whole case. It's fairly simple, just a little wonky, but in summary, what the case said was the presence of legitimate charges do not categorically bar or insulate police from being sued for illegitimate charges, meaning charges that did not really have probable cause to arrest someone for. So this has a few other factors, like he was held in jail. It's not about the arrest seizure, it's about the detention and jail seizure. But that's what this case said, which some police I've already seen online are kind of freaking out, saying, oh my God, anytime a person wants to sue police, if there's not a conviction, that was after Thompson v. Clark, they flipped out, saying if it's not a conviction, any arrest that does not lead to a conviction, they can sue for false arrest. No, that's a big misunderstanding. That means Thompson v. Clark meant that the Supreme Court said that one of the three elements is satisfied so that people can at least sue police. Doesn't mean they'll win. If the other two parts are also satisfied, like intent, the police have to intend to do a false arrest. And in this case, they lied on the affidavit, so they did intend it. But if it's an honest mistake, then you still can't even sue. But after this one, people could think it makes it easier to sue police because if there's one charge that's determined to not have probable cause, then the other charges don't save the cops from being sued if they were legitimate. But again, there are still the three-prong test. Those three prongs being the intent, the initiation of legal process, and a favorable termination of the case. So still very hard for cops to be sued. And again, they also are protected by qualified immunity. So there's still a lot protecting police. So this doesn't make a massive difference, but this makes, I think, substantial enough difference in clarifying that you can sue police if they arrest you and you're charged with something that's not based on probable cause, especially if there's really bad intent, like malicious intent, like lying on an affidavit, which again, I'm curious, have the cops been prosecuted for perjury? Because I'm pretty sure I know that every affidavit says, like, the police officer hereby swears the foregoing information on penalty of perjury, blah, 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 will be criminally prosecuted if they lie. So, whatever, I guess not. But that's the case, and thankfully we kept this under 25 minutes. I'll publish this along with the article, and the article along with this, and please let me know if there's any other cases that you want me to discuss. Someone wanted me to discuss the Mifid-Pristone case, and I might do a video on that next. But let me know what you think. Please let me know if you have questions. Let me know what I got wrong. I'm sure I got everything wrong, as always. So thank you very much. Check out libertyblock.com for more. And check out the podcast on your favorite podcasting app or Rumble, Odyssey, Facebook, or anything else. It's called The Liberty Block. Thank you very much. You can email me at alu, A-L-U, at libertyblock.com. Thanks, and have a great day, and enjoy Independence Day. Secession Day. Bye.